Okay, I got 17 months in on the protection orders from that girl, and the domestic violence case got dismissed. Okay, how they still got protection orders beyond me. Okay,
All right.
there's no domestic violence case for the protection order. Where's the domestic violence case for the protection order? There's no burden of proof.
Third attorney on this case. Mr. Moss, I realize you.
What is going on?
I'm sorry?
Hold on, Judge, let me pause the record.
Today, and the proposed plea offer he made is rejected. Therefore, the question is what to do next. And I talked to him about getting it set for a jury trial. He brought up issues of wanting me to file a bond motion and maybe get him, he's interested in participating in the Genesis program. I don't know if he can start that before trial or before a plea. And he had some legal issues he wanted me to investigate regarding the charges.
Okay.
So I proposed to your staff another pretrial, hopefully soon because he's in custody, but and then set up for jury trial. I think that's consistent with what he wants, unless he can. Yeah, he just nodded his head in agreement. Oh, I'm sorry, Your Honor. Yeah, the bond issue will be released. His mother's having very, very serious health problems.
Hospice is coming in.
Yeah, and he would like to be able to assist her in what could be her final days.
Okay, so he's got two charges.
Yes.
Aggravated possession of drugs, a felony 5,
Yes.
and violating protection order, felony 5.
Yes, Your Honor.
Lowest level felonies that you can have, but they are felonies.
Yes.
You're his third attorney. We're running out of attorneys. So I'd like to know, first of all, what the problem is that we now are on the third attorney.
Oh, well, I've not had a problem with him, so I don't know what the other...
Okay, all right.
Judge, I've been through this from day one on this case. We've been through this with Mr. Kidd, we've been through this with Mr. Newberger, and now with Mr. Moss. I can just sort of give you a little bit of background on this because I know you are new to the case as well, seeing as we had a recusal from Judge Teep. Mr. Blevins' bond has been addressed. He was previously let out on an electronic monitoring by Judge Teep. He cut off his ankle monitor and was MIA for a while. That's the reason why he's back in custody. So the state would adamantly object to him being released at this point. He is definitely a flight risk. He's proven that to be so. In addition, of course, the violation protection order does have a victim involved, so we would have to notify her as well. But speaking with her several times, I feel very safe in saying that she's going to object as well, but she's still entitled to that 10-day notice. At this point, Judge, he has been presented with his version of a plea offer is dismiss the protection order violation. That's not going to happen. My proposal is he pleads to both as charged 2 felony 5s. I do not have a strong position as to sentencing. I recognize these are both presumptions of probation. If he wants to get evaluated for some program, I don't have any objection to that as well. I can't speak on behalf of the victim and to say what she would be asking the court to do, but from a legal perspective, I am prepared to defer to the court in your decision.
Okay, thank you. Mr. Blevins, first of all, you're presumed innocent of these charges, and no one's assuming you're guilty of the charges. The prosecutor stated that she feels she has very strong evidence in the case, but no one's presuming you're guilty. But the case has to get resolved. It may not be your fault. I don't know why you've got 3 attorneys on this case. The issues regarding bond, she's making a good point. You released on a monitor and you cut the monitor off. Don't expect to see daylight again until this case is resolved, period. End of sentence on that. Now, let's move on. You're entitled to a trial. You can have a trial by a judge or a jury of 12 people. Your attorney, I'm sure, has advised you of that. He needs a little time to prepare, but we need to be moving on this case. You've been in, I don't know how long you've been in jail. You've been indicted almost 4 months on the protection order case. So I'll go ahead and, is there anything else you wanted to say on bond, Mr. Moss, that hasn't been said?
Well, Your Honor, I think, and you said end of sentence, and I understand that, but just so he knows he's been heard, he collects SSDI involving his feet, And I have seen a case like this before. He claims that the monitor was actually starting to scar his skin and that he was picked up at his house. He did do what they said, but he was at his residence. He never fled or absconded.
Yeah, 2 hours, like 2 hours later. I got 3 scars on my left ankle from the monitor. I couldn't even walk up and down the stairs no more. I got to take care of my mom. I got to take her to the bathroom and everything. I got to change her diaper. I got to wipe her butt and everything. My mom's getting ready to die. Okay.
Okay.
I'm taking care of my mom. Me and my twin brother takes care of my mom. She's on her deathbed. Okay.
Okay, when I hear that someone cut their monitor off, and that's generally a sign that they're not going to abide by the rules of probation. You're saying there's other factors involved. We'll set it for a bond hearing. By law, the victim's entitled to 10 days notice. We'll have a bond hearing. We'll also set it for another pretrial that will occur on the same day of the bond hearing. At that time, we're going to either set it for trial or plea. As far as Genesis, there are 2 things to look for in a situation like this, especially with the protection order. 1 is there a substance use problem. 2 is, are there mental health issues? And if there are mental health issues, that plays a factor in whether or not you can go to Genesis or to other places. But we generally focus on treatment for people who are willing to do better. And for people who are not, if they're convicted. So I don't have a problem with Genesis. I like the place. There are other places that are good as well. But we have to have an assessment to know what they need to treat you for. So we'll set it for another pretrial and a bond hearing. It'll be within 2 weeks in order to give the 10-day notice that we're required. And at that pretrial, we'll get a trial date if it's not resolved. Is there anything else, Ms. Tranter?
No, Your Honor, thank you.
Mr. Moss,
No,
anything
Your Honor,
else?
thank you.
All right, that's all. Yes,
Can I
sir.
say one thing?
Yes.
You know, I've been in jail since July the 8th of last year over the same protection order. Okay, I got 17 months in on the protection orders from that girl, and the domestic violence case got dismissed. Okay, how they still got protection orders beyond me. Okay, but I got 17 months in jail on that protection order from that girl, and that's my brother's old lady. She ain't got nothing to do with me. She's living in my mom's house for free. Okay.
Well, this case didn't get indicted until May of this year, so I don't know the story about what happened before, but all I'm telling you is we're going to address the issues now.
It's the same protection order.
Okay.
The protection order is no good.
All right.
There's no domestic violence case for the protection order. Where's the domestic violence case for the protection order? There's no burden of proof.
Then have a trial.
All right.
Okay, that's all.
Thank you.